Morning everyone, and welcome to this morning's webinar on defamation and privacy, an update on recent litigation and some key trends. So just by way of introduction, I am Christine O'Neill and I am a partner in our Government Regulation and Competition team, and this morning's webinar is being presented by myself and Niall McLean, who's also a partner in the GRC team. Each of us advises on defamation, privacy and other media related issues for a range of clients, both claimants and defenders, if I can use that language, and we hope to bring you something of value this morning. We are going to talk about the greater use of litigation in this area, mainly in the English courts, but we're certainly seeing it in the Scottish courts coming through as well. It's certainly not an area where I think it would be fair to say historically there has been a lot of litigation in Scotland, but we are seeing it becoming a more active area. And certainly I think both of us would say that even if we don't find ourselves in court all of the time, we're certainly seeing a great increase in the number of potential claims, pre-litigation action, and indeed claims resulting in out-of-court settlements. In terms of our audience this morning, I'm very conscious that we have an audience made up of colleagues and delegates, some of whom are very expert in this area and some who come from a more generalist background. For those of you who are specialists, I apologise. We will be aiming to make this as accessible a webinar as possible, so it may not involve quite the legal analysis that you might be used to, but we hope nevertheless that it is of some benefit. We're going to talk about the law of defamation in Scotland and some recent cases on defamation. We're also going to talk a bit about the Defamation and Malicious Publication Scotland Act of 2021. We'll then come back and talk about the broader development of the law on misuse of private information, and we'll finish up by saying a little bit about class actions, particularly in the context of data breaches. What I'm going to do now is hand over to my partner Niall McLean to kick us off on the defamation part of the webinar.
Thank you, Christine. I'm going to give you the basics in the law of defamation, help you identify some common defences, and also provide an update on recent changes to the law introduced by the 2021 Act, which Christine referred to a moment ago. And the idea being here that we want to help you spot defamation when you see it, and to allow you to start to think about how you might respond. Another reason we wanted to deliver this session is because, and it's right to say, reputation is a valuable asset to individuals and organisations. And the Scottish Government recognised that in the policy memorandum to the 2021 Act. They explained by reference to a study undertaken by Deloitte that 87% of executives had rated reputation risk as more important or much more important than other strategic risks that their company were then facing, with the biggest impact of reputational damage being felt in a loss of revenue and a decline in brand value. And given that the rate of which information can now spread, including across social media, it's arguably never been more important to protect your reputation. So what is a defamatory statement then? Well, it's words that would tend to lower a person in the estimation of right-thinking members of society. That definition is slightly changed by the new Act, which we'll come on to later. It sounds very old-fashioned. It's a legal definition. However, in most cases, identifying whether something is defamatory or not is straightforward. We tend to say, you know it when you see it. Recent examples in the public domain include Kezia Dugdale describing the operator of the Wings Over Scotland blog as homophobic in a Daily Record article, and the Sun newspaper describing the actor Johnny Depp as a wife-beater in an article about the most recent Fantastic Beasts film. Both of those defamatory statements were protected by available defences, and I'll come on to talk about those cases in a bit more detail in a moment. Currently at the moment in Scotland, when a person communicates, shares a hyperlink or temporarily stores defamatory material online, they are theoretically liable under the law of defamation. However, there are protections and defences which exist to allow for the fact that the internet and modern technology give rise to a wide range of circumstances where defamatory material might be posted on a platform, but it's not subject to editorial review by the operators of that platform. I'm going to discuss later on how reform deals with the issue of publication and secondary publishers. However, it's important to note that if you are operating a platform like that, even though you might not be liable to be sued in an action for defamation, it's really important that you engage with defamation law. User terms and conditions will obviously provide for user responsibilities and your platform's right to take action about content, but you'll still have to engage with defamation law potentially when aggrieved parties approach you seeking to have content removed. So moving on to look at some examples of recent defamation cases, they really help demonstrate what is defamatory and the types of defences that can be applied. Unusually for Scotland, there have been a number of recent reported decisions, and again that perhaps reflects a wider trend that individuals and organisations are more willing than ever to take steps to protect their reputations. I'm going to start with the case of DEP against News Group Newspapers Limited. As I mentioned, this involved the Sun publishing an article describing Mr. Depp as a wife beater. And one of the key defences to any action of defamation is that if the statement complained about is true, then it will be protected. So although it's clearly defamatory to describe an individual as a wife beater, the Sun was able to establish that on the balance of probabilities that statement was true after a trial, as it's called in England, in which evidence was heard. And in particular, they were able to establish that of the 14 incidents of alleged violence that had occurred, 12 of them had been proved to have been more likely than not to have happened, and that's the civil standard of evidence. Moving on to Campbell against Dugdale. This, as I mentioned a moment ago, was about Kezia Dugdale's article in the Daily Record, where she accused the publisher of the Wings Over Scotland blog as being homophobic. And it illustrates another common defence which is available, which is the defence of fair comment. It's going to be recast as defence of honest opinion. I'll come on to talk about that a bit later on. The defence of fair comment provides a level of protection for freedom of expression by allowing for fair opinions to be stated where there's a factual basis for those opinions. So it's based on a distinction between statements of fact, which are supposed to be true, and statements of comment, which are open to debate. And the easiest way to think about fair comment is that it's someone's take or observation on a particular issue. The Court of Session found that Ms. Dugdale's statement that the operator of the Wings Over Scotland blog was homophobic was protected by fair comment, taking into account Ms. Dugdale's own genuinely held views and also what an objective reader might take from the article. Moving on to Wildcat Haven. So Wildcat is a private limited company registered in England, and it was a fundraising vehicle for a company which had as its object the conservation of Scottish wildcats. The defendant in this case, Mr. Whiteman, published 2 blogs which were said to contain defamatory statements. And the defamatory statements mainly focused on the allegation that Wildland operated through a tax haven and was acting illegally. And the action failed because the statements were either not defamatory or defences applied. And the reason I wanted to mention this case is it's a really helpful decision as it runs through many of the key legal principles in defamation cases. And the one that I want to focus on is that in working out whether something is defamatory, the test is what the ordinary reasonable reader would understand from the material. And again, that's another legal definition. But what that means is that the context is important in relation to words used, and it's particularly important in relation to words used on social media. And what the court will do is keep in mind that such postings and the way in which such postings and tweets are made and read. Social media is often described as a casual medium. So what that means is you can't engage in the same sort of elaborate analysis you might do in a longer written article. you have to think about the fact that people scroll through Facebook posts and Twitter posts quickly. They don't pause to reflect on what meaning a statement might possibly bear. So that instinctive reaction to what you read on Facebook or Twitter is important in establishing whether or not something is defamatory. And finally, in terms of cases, I just want to mention the case of British Gas Trading Limited against McPherson. And this is an important case when you're thinking about what you might do about material that's posted. It was an action brought by British Gas requiring a blogger to remove certain blog posts and seeking orders for the court in order to for that to happen. It's interesting to me because of the rise of alternative forms of journalism and statements that can be taken to remove defamatory material posted on blogs. So this is the second part of this case. British Gas had already obtained an interim interdict which prevented a blogger from posting defamatory material which had alleged that corruption and dishonesty. And they came back to court to get an order requiring interim removal of the blog posts, and that order was granted. The argument against British Gas was one of freedom of expression, but the court explained, as we know, that the right to freedom of expression is a qualified right. British Gas had to protect their reputation and business interests, and there would have been prejudice to those if the posts were not removed. So weighing up the respective rights of British Gas and the individual, and who was going to be more prejudiced by the material remaining on the blog site. I want to move on now to talk a bit about reform of the law of defamation in Scotland. So we now have the Defamation and Malicious Publication Scotland Act 2021, and I'll move on and take you through some of the key provisions of that act. It's received royal assent, but it's not yet been brought into force, save for the interpretation provision. So it could happen any day now. So it's important to bear in mind at this point in time that we're still operating under the old law, but you should look at the new law and make sure whether it's in force or not before you take any steps in defamation. The aim of the Act really was to simplify and modernise the law of defamation in Scotland. It does all sorts of different things, but in the time allowed, I'm just going to try and summarise some of the key changes that are likely to impact on this area. The first of which is the introduction of a serious harm test. That is a threshold test of serious harm before a person can bring defamation proceedings. The Act clarifies that serious harm for commercial entities, and those are entities with their primary purpose being trading for profit. Serious harm in that context requires serious financial loss or the likely prospect of serious financial loss. So quite a significant change if you are a corporate entity bringing an action to protect your reputation. Otherwise, the Act doesn't specify what constitutes serious loss. And that question of serious harm and serious financial loss is going to be a factual question. So it's no longer sufficient just to point to the words and say, those words will damage our reputation. You actually have to now prove that that has happened, and that's quite a significant development. The introduction of this test brings the position in Scotland into line with the position in England, and it's likely that the English cases dealing with serious harm are going to be persuasive here. There's also now a requirement for a defamatory comment to be made to a third party. This is always quite a bizarre one if you're giving clients advice about defamation. At the moment in Scotland, you don't need to make a defamatory statement to any person apart from the person it's about. But the 2021 Act brings the law of Scotland into line with other jurisdictions requiring publication to a third party before a defamatory statement becomes actionable. It also makes a lot of changes to the law of verbal injury. Verbal injury is a type of claim that's similar to defamation, and it addresses statements which are likely to be damaging to individuals, though it's legally distinct from defamation. And there are changes made there, which I won't go into in detail at this stage. Another thing the Act does, and conscious that we're joined by viewers from public authorities this morning, the 2021 Act codifies the principle that a public authority has no right to raise proceedings in defamation. It's not because a public body doesn't have a reputation, it's because a public body should be open to uninhibited criticism. However, there is no barrier to an individual who holds some form of public office from bringing proceedings in a personal capacity, albeit very careful consideration would need to be given by public authorities as to whether they would support individuals who may wish to take steps to protect their own reputation. Another significant development in the 2021 Act is it takes some of those defences that I've been talking about and it puts them on a statutory footing for the first time. Under the law of defamation, when the court determines that a statement is defamatory, the burden is then on the defender in the action to establish that the defamatory statement is covered by a relevant defence rather. And there are a number of defences that people can run. We've talked about truth already, and that will become a statutory defence in the 2021 Act, as will fair comment, which becomes honest opinion. And the key difference there is that the requirement for it to be a comment on a matter of public interest has been removed. So simplifying the defence of fair comment and putting it on a statutory footing. And finally, a defence I've not mentioned, which is a common one relied on by the media, is that the defence is in a publication on a matter of public interest. So where a person can show that a statement concerned a matter of public interest and they reasonably believe that publishing that statement in question was also in the public interest. So that allows for the contemporaneous reporting of material which may otherwise be potentially defamatory, and it provides defence to that. The other change which is relevant if you're considering bringing an action is a procedural one, which is the reduction of time bar. The Act amends legislation to reduce the time limit for bringing an action for defamation from 3 years to 1 year. And there are also restrictions on actions against secondary publisher. The general position under the 2021 Act is that there's no right to bring defamation proceedings against a person unless they are the author, editor, or publisher of the statement. The definition of publisher refers to commercial publisher, so that is a person whose business is issuing material to the public and does that in the course of a business. So again, looking at the attendees today, that ought to catch some people who are viewing the webinar. That definition should be narrow enough to exclude social media platforms through which defamatory statements are made. But in any case, the Act provides that parties are not to be considered authors, editors, or publishers where their involvement with the statement is only processing any electronic medium in or in which the statement is recorded. The 2021 Act also contains a number of exclusions as to who is considered an author, publisher of a statement. But it doesn't, for anybody who is joining from social media, it doesn't contain the same approach taken in England, which created a specific defence to an action of defamation for operators of websites to show that they were not the party that posted the statement on their website. So that is one difference that remains between Scotland and England. And with that update on the law as it's about to be, I pass back to Christine.
Thanks, Niall. And so if we move on, we're going to change the topic a little bit here to talk about private information. This is one of my favourite quotes from Banksy, and I use it as my defence to our business development and marketing colleagues when they complain that I don't have a Twitter account, I don't have a Facebook account, I don't have an Instagram account, I don't have anything else by way of social media presence. I prefer my superpower of invisibility, but not everybody does. And if we move on, we are in the territory of the use and the misuse of private information. And I think what we'd say about this is that we are seeing, and it's evident from what's happening in the courts, that there's an increased willingness by a whole range of people to pursue claims based on the wrongful use of private information. And that can be categorised in a number of different ways and appeal to a number of different legal concepts. But it at base is people complaining about the use of information of theirs, which may be true, but which may nevertheless be sensitive and private, and which they don't want publicised or brought to the attention of others. So it might be categorised as a breach of data protection laws, including we know that we have the right to be forgotten. There might be a claim based on the DPA and the GDPR. There might be a claim based on breach of Article 8 of the European Convention on Human Rights, which is the protection of private life, family and home. That's particularly relevant to public authorities who will have direct obligations under the European Convention, but it's also relevant to the development of the common law because of the court's obligation to have regard to and give effect to the convention. And claims might be characterised as claims of misuse of private information or breach of confidence as common law complaints. And what I should say is that oftentimes you may have in the same litigation a number of these complaints overlapping, and the law tends to bleed from one area into another. So these categories are not necessarily always watertight. So you might be thinking, if we move on to the next slide, that misuse of private information as a concept is really for celebrities who have big legal budgets, big legal teams, and the resources to pursue large media organisations. And you should, and will be, I'm sure, be aware of the Cliff Richard case. The background, if you remember, was that the police had given advance notice to the BBC of a search of Cliff Richard's home in connection with allegations of sexual abuse. Having been given notice of that search, the BBC broadcast fairly extensive footage of the search, including footage shot from a helicopter over Cliff Richard's home. And Cliff Richard's claim was that the BBC and the police had breached his rights under Article 8 of the European Convention, and that he was entitled to damages for that breach. Now, one of the defences that the BBC put forward, and a key part of the defence, was their argument that Cliff Richard had no legitimate expectation of privacy in the fact of the investigation. And the BBC also argued that its own rights of freedom of expression outweighed his Article 8 rights to privacy. And those arguments reflect some of the key elements of misuse of private information or breach of confidence, or indeed Article 8 claim. In order for those claims to get off the ground, you have to be dealing with private information. In the common law, it would have been described and is described as information having the necessary quality of confidence or of privacy, of sensitivity in Article 8 terms, whether it impinges on your private life. There has to be, for a claim, there must have been unauthorised use of that information to your detriment. And two of the key elements of figuring out whether there is liability are these questions of, does the person have a legitimate right or expectation of privacy, and how does that balance against questions of freedom of expression for the press. What the court said, importantly in this case, was that because of the stigma that police investigations carry with them, ordinarily, and it's an important caveat, ordinarily, a suspect will have a reasonable expectation of privacy in relation to the investigation of allegations against them, and that expectation extends to searches. The court said that there was no public interest that justified identifying Cliff Richard as the subject of investigation, so he hadn't been charged, hadn't been the subject of a decision to prosecute. This was all at the investigation stage. And the court also said that the fact that he himself had adopted public positions on, for example, Christianity, didn't diminish the weight of his right to privacy, and none of it was outweighed by what was argued by the BBC to be their interest in freedom of expression. And he was awarded very substantial damages and legal costs. But these cases are not only for celebrities, even in the media environment. So if we move on, not a programme I must confess I've ever watched, but there is apparently a programme made by Channel 5 called Can't Pay, We'll Take It Away, which is essentially looking at bailiffs taking property from people who are in debt. Nice concept. And the case of Ali against Channel 5 involved a situation in which a couple, Mr. and Mrs. Ali, were filmed while bailiffs were evicting them for non-payment of rent. And what's important about this case is the factual matrix, and I think this is something we would emphasise in all of these cases. The particular facts will be looked at excuse me, carefully by the court. Here, we had a situation where bailiffs arrived at the house. They didn't explain to Mr. Ali, who opened the door, that they had a film crew with them. They entered the house and they filmed footage of Mr. and Mrs. Ali. Mr. Ali in his night clothes, in a situation where Mrs. Ali repeatedly asked the film crew to stop recording. There was no attempt by the broadcasters in this situation to obtain the consent of Mr. and Mrs. Ali to what was going on. And part of the claim that was made by the Alis, as is recorded by the Court of Appeal, is that the programme showed them at their lowest ebb, being evicted without prior notice, in a state of shock and very distressed. And their argument was that that of itself caused a loss of dignity to them. And the Court of Appeal said that was important in the context of this kind of claim, because of something Lord Hoffman had said in Naomi Campbell's claim against Mirror newspapers. You'll remember that Naomi Campbell was filmed going into a Narcotics Anonymous meeting, and one of the things that was said in her case was that a claim for misuse of private information bears on, is important for the question of human autonomy and dignity, and the court's concerned where there is an infringement of or an impingement on that human autonomy and dignity. And because of the various factors here, being in the house, the state of undress of Mr. and Mrs. Ali, the absence of consent, the fact that they were being filmed at a vulnerable moment in their lives, was not again outweighed by Channel 5's interest in broadcasting this footage. And Mr. and Mrs. Ali were made an award of damages of £10,000 each. Now, again, you may be thinking, well, this isn't relevant to me if I'm not working in the media or I'm not involved in cases that are about broadcasting in a media context. Again, just to highlight that that's not quite the case. If we move on to the next slide, and this one just reflects the points that I made already about what amounts to misuse of private information. Just to make the point that in Scotland, our law is closely aligned with that of England. And I've mentioned the legal test around the question of whether there is a legitimate expectation of privacy, whether we've got material that has the necessary aspect of confidence, whether it's been used to a person's detriment, and where the public interest in freedom of expression lies. If we move on to the next slide, this is an example of a question of misuse of private information arising not in a media context, but in the context of disciplinary proceedings in a workplace environment. And again, some of you attending may have read about this case already. C against the Chief Constable of the Police Service of Scotland. It's a really interesting case, I suppose, because of the factual background. An investigation was being carried out into a serious sexual offence. The devices of these particular officers were examined. None of the officers in question were persons of concern, suspects in the investigation, but their devices were looked at. And as part of the investigation, the investigating officer identified on their devices a number, I think 2 distinct WhatsApp message groups and a large number of WhatsApp messages, and you will see the how those messages were described. The quote that I've used on the slide comes from the decision of the inner house of the Court of Session, so a three-judge bench, which was reviewing the decision of a judge, the Lord Ordinary in the outer house, which had reached the view that this material could be used in disciplinary proceedings against these officers. The first judge had concluded, and the Inner House agreed, that a reasonable person looking at the messages would be entitled to reach the conclusion that they were sexist, degrading, racist, anti-Semitic, homophobic, mocking of disability, and included a flagrant disregard for police procedures by posting crime scene photographs. So the question for the court was whether a number of questions for the court, but the first question for the court, which is a kind of threshold question, is whether the officers had any reasonable expectation of privacy in relation to these messages. And shortly put, the court concluded that they did not have any such expectation of privacy. The court accepted that correspondence, including WhatsApp messages, would ordinarily engage Article 8 of the European Convention. It would engage their rights to privacy in relation to correspondence, which would include WhatsApp messages. But as to whether there was an expectation of privacy that would prevent these messages being used as part of a disciplinary process, there was not. And again, the facts are extremely important here, because one of the things that was significant for the court was that the content of the messages themselves, the court found itself entitled to say, that content would call into question the suitability of those officers to be police officers. So their status as constables, their status as occupiers of public office was directly relevant to the question whether they had an expectation of privacy in relation to those messages. And there's another example from the English courts of comments made by a barrister in a robing room to another barrister, which then became the subject of a complaint to the Bar Council. And again, it was concluded that while a robing room would ordinarily be a place where you might have an expectation of privacy, given the nature of the comments that had been made by the barrister, they did not have that expectation of privacy, and this could be used as part of a disciplinary process against them. So we're not just in a media or a broadcasting environment when it comes to the misuse of private information. If we move on, this is again just a case that you may or may not have been aware of at the time when it came out from the Supreme Court, and it's of particular relevance, I think, to those of you who may be concerned about what your employees do with private information and whether you are going to be liable for breaches of the law committed by employees or those who work for you, whether contractors or otherwise. It's Morrison's Supermarkets against a range of claimants, and the issue here arose because Morrison's had an internal auditor, an employee who became disaffected with Morrison's and had a grudge against the company, and to give vent to that grudge, he downloaded a range of personal data belonging to other employees, including payroll data, put that on a memory stick, took it home and put it up onto a data sharing site, causing obviously a breach of privacy for the employees concerned, and on the face of it, a claim for breach of the Data Protection Act against Morrison's by the employees who were affected. And one of the key questions for the courts, and this went to the Supreme Court, was the question whether Morrison's were vicariously liable for what was done, or whether the liability for what was done rested solely with the individual rogue employee. Now, it's an important case for our colleagues who deal with negligence questions and employers' obligations in relation to employees more generally, but in relation to private information, the Supreme Court concluded that in this particular case, again by reference to the particular facts, Morrison's was not vicariously liable for what had been done by the employee. To use the old language, the employee was off on a frolic of their own, and what was done by the internal auditor was not closely connected enough with what the employee was authorised to do in his role for Morrison's as to make Morrison's responsible for those breaches. Now that case can be compared with a case that's not on the website, but I can send the details to anyone who's interested. A case called TLT against the Home Office, and that was dealt with by the Court of Appeal in 2018. And again, different facts. Here, the Home Office, in error, put on its own website what should have been private information about asylum seekers. There was no question of someone going off in a frolic of their own with a malicious intention to do this. It was a straightforward but serious error by an employee. There was no question of there not being responsibility for that breach by the Home Office. The Home Office was responsible for the breach, and the claimants in that case were awarded damages ranging from £12,500 to £2,500, depending on the particular person and the nature of the information that had been disclosed about them. So there is no absolutely straightforward and clear line dividing those cases where an employee will be responsible for this kind of data breach and those where it will not. But the test is how closely connected. And she says the test as though the Supreme Court hasn't taken pages to articulate it, but in 3 lines, the test concerns how closely connected with what you are doing, you're doing for your employer, how closely it's connected with your daily work. Finally, just to mention, Reed against Price, a colleague suggested putting this case on the slides, I suspect only because the facts are fairly lurid. This involves Katie Price and Alex Reed, and video footage that Katie Price had obtained of Alex Reed while they were married, involving sexual conduct and cross-dressing, and her allegations of her disclosure of that and misuse of that private information. The case is relevant, not necessarily because of its lurid details, but because of the court's discussion of the factors that it will take into account when it's awarding damages and what goes into the calculation of damages. Now, I think this is an interesting case. I suppose the health warning is that I've not seen it applied in the Scottish courts, and we've yet to see, I think, how the Scottish courts will grapple with how they will calculate awards of damages and misuse of private information claims. One of the factors in Reed against Price, only one though, was that the court in England said that awards of damages in defamation cases may be a relevant factor when you're trying to figure out how much should be awarded in a misuse of private information claim. I'm not sure that whether that means that in Scotland we might see awards of damages that might be a little bit less than those in England, because certainly we would ordinarily expect awards of damages in defamation cases to be a little bit lower in Scotland than they might be in England. So I mentioned Reed against Price for your interest, but really just to take it with a little pinch of salt. So if we move on, we have to mention the Duchess of Sussex against Associated Newspapers, because it is one of the most recent cases, and again well known to those of you who read the Sunday Mail and the Mail Online, but publication of a letter from Meghan Markle to her father, and she obtained summary judgment. That's effectively a kind of slam dunk from a court. So the court took the view that there wasn't any need to hear evidence about what had happened here. It was satisfied that the Duchess of Sussex had made out her case by reference to, again, a number of different causes of action. And as I've mentioned, many of these claims do combine different arguments and different legal bases. This involved an argument about copyright as well as misuse of private information. And I think one of the things that comes across very strongly from this case, and it comes across to a degree from Cliff Richard as well, is that public figures are nevertheless entitled to a degree of privacy and to the protection of their private life. And the court was unimpressed with the arguments made for the newspapers concerned that the Duchess of Sussex had, in some respects, surrendered that privacy because of her position and other engagement with the press. That's all I'm going to say about misuse of private information, and Niall is going to round things off with some discussion of class actions.
Thank you, Christine. So in this final section of the webinar, we want to talk about class actions following data breaches. And we want to talk about that because actions involving defamation and misuse of private information will more often than not involve individuals. And their claims can often be brought as a combination of different types of privacy litigation. And it's also the case that in many cases where there has been a personal data breach, that reputational harm might often follow from that. I want to focus on class actions because those are going to be of particular interest to any organisations that have joined this morning's webinars. And when we talk about class actions following data breaches, what we mean is individuals joining together to bring group claims. In Scotland, new class action rules have been in effect since last July, and they're called group proceedings rules. And the purpose of those is to allow for claims of low economic value to be considered together due to similar questions of fact or law. For claims that are of such a low value that they may not be worth raising on their own, the use of group proceedings makes it much more viable for individuals to bring claims. The use of court proceedings and group proceedings for individuals seeking compensation from a data breach is a good one if you're an individual, because data breaches are likely to engage identical questions of fact or law amongst a large number of people. So you get over that initial hurdle for a group proceedings in a way that you might not for other types of breach. Unless the data breach includes particularly sensitive information, then a person will not normally be entitled to a large sum of damages. So again, makes it economically viable to group together with others to bring a claim. And the final point that I would make is that bringing a claim under data protection legislation is a complex task. For those involved in advising on data protection law, they will know it's a complex piece of legislation. And that would be particularly true for any individual seeking to try and make out a claim for compensation where they don't have legal representation. So all those things make group proceedings attractive in data protection cases. We do now have some high profile class actions in this area. The first case I want to talk about is Lloyd against Google. It's a class action brought against Google on behalf of just over 4 million iPhone users, alleging that Google acted in breach of its duties as data controller under Section 4 of the Data Protection Act 1998, which was in force at the time. And what Google is accused of doing is using a workaround on Apple's Safari browser, which permitted Google to bypass the blocking of third-party cookies and collect and use browser-generated information about people. This claim was brought as a representative action in England, and a representative action is a type of class action which allows for a claim to be brought by a claimant as a representative on behalf of all those who have the same interest in the claim. So at the moment, we only have the Court of Appeal decision. The Supreme Court heard this case in April of this year, and their decision is anticipated soon. But the three parts from the Court of Appeal decision that are relevant are that the Court of Appeal said that damages are in principle capable of being awarded for loss of control of data, even where there is no financial loss or distress. The second thing that's important from the Court of Appeal judgment is that whilst they said it was unusual to bring this sort of opt-out style class action, it was permissible because the members of the class here all had their browser-generated information taken without their consent in the same circumstances and in the same period of time. So they were all victims of the same alleged wrong and all sustained the same loss, so apt to be brought together in the same action. And the final thing is that there was a procedural point about whether the High Court ought to have allowed to exercise its discretion for this action to proceed, and the court said that the High Court was correct. So wait and see what the Supreme Court say about this case. If the Court of Appeal's decision is upheld, it's quite a significant decision because it would arguably pave the way for US-style class actions for data breaches. And you can see that in some other examples that are also coming forward before the courts. The case of Oracle and Salesforce, which is a £10 billion claim filed by privacy campaigners in the UK and the Netherlands. And that claim alleges that Salesforce and Oracle collected users' personal data without their consent and then auctioned it off to other companies without their knowledge. The UK claim demands a payment of £500 for each user. So you can easily see there how that can be escalated up into quite a significant claim when any one individual within that group only is claiming a small sum of damages. The court proceedings in Oracle and Salesforce are currently paused, awaiting the outcome of the Google case, as are the proceedings against BA, who is facing approximately £2 billion worth of claims for incidents in 2018 and 2019, where customer bank information was accessed. Again, the claimant firms in that case are waiting the outcome of the Google case. But we simply flag them because it makes the point that the customers and public are aware of these types of claim, and the interest in bringing them is only going to increase, particularly given the litigation funding options available now. So I'll just move on to flag those. I mean, we're keen to get to some questions. I won't say too much about litigation funding, but since April 2020, in Scotland, it's been possible to enter into success fee arrangements. So these allow for damages-based agreements where a solicitor recovers a share of the damages in the case of successful claim. They allow for speculative fee arrangements where a solicitor is paid an uplift from damages that are awarded, and also hybrid arrangements where a mixture of solicitors being paid on an hourly basis and partly by success. The relevance of all of this is in relation to potential for data protection class actions in Scotland, because they ultimately are another factor that facilitate large groups of people being able to raise actions. There is nothing new really in litigation funding options, but what they may do, particularly in relation to the development of success fee arrangements, is encourage people to engage with externally funded litigation at a lower cost, effectively moving the risk away from the pursuer in an action to the external funder, with an agreement that if damages are recovered, solicitors' fees would be deducted from those. So what can you do then to prepare or mitigate against this new type of class action in Scotland in particular? Well, obviously there are a number of steps that you could take. The first of which we would strongly recommend is that you review your insurance arrangements to ensure there is sufficient coverage, that funding will be provided in response to this sort of class action, including in respect of a data breach. So looking in particular at whether you've got cybersecurity cover in place. Generally to review your procedures and how you would respond to a privacy litigation incident. So thinking about who you're going to notify alongside your insurers. Are you going to involve any external support? So for example, have you already identified PR support that might engage with any reputation management issues that arise? And all of that, having a plan in place will be key to ensuring that you respond appropriately. What we're talking about here, of course, is litigation. So really getting that message right at the start and ensuring it's consistent is important, because that not only helps ensure that you deal with issues in an appropriate way, and hopefully in a way that if you've got customers that keeps them happy, but it also avoids litigation potentially, or if litigation can't be avoided, ensuring that you've had a consistent and well communicated approach throughout, which you can then present to the court in respect of any claim. So that, I think, is all we wanted to say this morning. We're now, I think, in the position, Kristen, to take some questions.
Yeah, thanks, Neil. And I would just add to what Neil has said about engaging lawyers, not as a sales message, but one of the other reasons, at least to have in mind engaging solicitors at an early stage in relation to data breaches, is the protection of privilege, which that might give to internal investigations into what has happened, and that might prove to be quite important down the line. And certainly we know that some insurers take the view that For example, cyber security specialists should be instructed by solicitors in order to ensure that what is produced by them has the potential to be covered by privilege. So yes, in terms of questions, we've got a few, but please do put yours into the Q&A if you have any. Niall, I think this one really is for you, and that is in terms of the new Defamation Act. Is there anything in particular that you are expecting will be in practice different about bringing or winning defamation cases? So what practical difference is it going to make to these cases?
So as I sort of touched on when I was speaking, I suppose the biggest practical difference is going to be for me the serious harm threshold. At the moment in Scotland, there is no threshold to bringing an action, and that would in theory allow fairly frivolous pieces of litigation to be embarked on, obviously subject to all the normal court rules about abuse of process, etc. But I think that's going to be particularly challenging if you are a corporate entity, because of that additional requirement to show serious financial loss. In old times, I suppose, in defamation actions, you could just point to something that was on its face very defamatory about your organisation and say, that's defamatory, therefore we've suffered a loss, and you're no longer going to be able to do that. And actually, what we've seen in the cases in England is, it can be quite difficult to predict what's going to happen in terms of that threshold test, because very fact specific, which obviously all lawyers will say, but you're going to have to produce pretty good evidence. And one of the challenges in that is, how do you measure, the damage to your reputation?
Yeah.
I think that's going to be really difficult.
Yeah, and that how do you measure the damage, I suppose, is another question which I think I answered as I was going through, but there was a question about whether damages awards in Scotland are the same as those in England. I think it's fair to say that we don't have a lot of visibility of actual damages awards from the courts. What we have seen are cases being settled out of court and tending to be in the low thousands of pounds, which may sound like a nuisance type of claim, but obviously if the claim gets up and running in a court and you're settling it, then you have legal costs to factor in, including the legal costs of any claimant. So that's something to bear in mind. Another point that I'm encouraged by colleagues to remind you of, Niall has spoken about class actions and the potential for class actions or group proceedings to be raised against you. Again, if you're familiar with how courts work in Scotland, and you are an organisation that might be on the end of litigation, you may already have in place caveats with the court. And to remind those of you, or to let those of you who don't know about these have some insight, a caveat is effectively a mechanism by which you are given notice if somebody makes an application to the court, normally for an interim order, some sort of interdict or order at the early stage of a case. If you have a caveat in place, you get notice of that from the court and the opportunity to make representations. And there is a new form of caveat that relates to group proceedings, and it's worth thinking about, even if you don't think you're the kind of organisation that's liable to be on the end of group proceedings for example, personal injury or the like. Group proceedings can arise in this context, so worth thinking about. Niall, another question for you, and that is on the question of public authorities and the kinds of public authorities that are not entitled to bring defamation proceedings as a result of the reforms made by the 2021 Act. And it's a question about whether universities, Scottish universities, would be within that umbrella of public authorities, and indeed whether they might be entitled to bring proceedings because they are charities. Now, it's not necessarily, I have no idea if you know the answer to this question, so I'm asking it anyway, and if you don't, we will follow up later on. But what's your answer to that?
So what the bill or now Act says about what amounts to a public authority, is to use language which we've seen in other pieces of legislation, like the Human Rights Act. So a public authority includes any person whose functions include functions of a public nature. And Christine and I have been advising the Human Rights Act for years now and know that that can be quite a thorny question for different types of organisation. I think in the case of universities, even though they are charities, what the court has said, it will be determined obviously on the individual facts, but if the predominant purpose of the organisation falls within that definition of including function of a public nature, then they'll be prohibited from bringing an action for defamation. And I think it would be quite difficult for a university to argue that it's not caught by that definition, just because it is also a charity. But I appreciate in giving that answer that might open up a whole other question about whether universities are public bodies or not, and it might be one that needs a bit of deeper reflection. But equally, Christine, happy if you've got anything to add to that.
Yeah, it's building on what you've said, because obviously the other point about public authorities under the Human Rights Act is that they're these hybrid public authorities if they're not core public authorities. And I think I don't think a university would be a core public authority, but would be a hybrid public authority. Some of the things it does will be categorised as private. Some of the things it does will be categorised as public. And there's a kind of open question for me about whether, in relation to its private activities, it might escape this definition. But I think as a matter of practical reality, most of the questions that will face a university in terms of defamation and its reputation, unfortunately, are liable to arise from its student body or people connected with its student body, and therefore most likely to arise in the context of the public functions that it's discharging. So to our questioner, I fear that we're not providing a very happy answer at this stage, but very happy to think about it in more depth. I'm afraid I think we have run out of time. Thank you for everybody who submitted questions. We'll try to follow up with those that haven't been answered after the session. Thank you very much for attending today and giving up your time for this session. We're very keen to hear your feedback if you think this was useful, or indeed if you don't think it was useful and you'd like us to look at something else in this area in the future. We'd be very keen to hear from you. But for just now, thank you very much and have a good day.
Thank you.
Bye.